Ready? 3, 2, 1, start. This writ petition has been filed for issuance of writ of mandamus to the respondents to direct the respondents to decide the representation dated 6 to 2013 and 5/3/2013 filed by the petitioner and further direct the respondents to re-grant the land of the petitioner which has been acquired by the respondents. Para. Learned counsel for the petitioner has urged that other persons have been re-granted the land and survey number 751 to 755 was ordered to be given to the agriculturists in the year 1991 by the government. Initially, it was decided by the government to re-grant the land of the petitioner, but subsequently this view was changed by the government as the land was acquired by the Gujarat Housing Board for the construction of affordable housing scheme. Though earlier the Housing Board has passed resolution on 31/5/1991 that there is no requirement of houses and therefore they do not acquire the land as communicated by the Housing Board on 17/5/1991 to the Urban Land and Urban Development Department, but the subsequently in the year 2010 the Housing Board wrote a letter on 16/3/2010 Annexure K to the writ petition that they acquired land for the construction of affordable houses. Therefore, the land cannot be re-granted to the petitioner. Para. Counsel for the petitioner has urged that the representations are liable to be considered and the land is liable to be re-granted to them as it has been re-granted to other agriculturists. Having heard learned counsel for the petitioner, we are of the opinion that the land once acquired cannot be re-granted to the agriculturist or the petitioner once the possession has been taken by the state government. In case of V. Chandrasekharan and versus Administrative Officer and others reported in 2012, SCC 133, the Apex Court has clearly held in para 25 to 31 that once the land vested in the government cannot be divested and cannot be re-granted to the petitioner. Relevant para numbers 25 to 31 are extracted below. It is a settled legal proposition that once the land is vested in the state, free from all encumbrance, it cannot be divested and proceedings under the Act. The said land once acquired cannot be restored to the tenure holders oblique persons interested even if it is not used for the purpose for which it was acquired or for any other purpose either. The proceedings cannot be withdrawn, abandoned under the provision of Section 48 of the Act or under Section 21 of the General Clause Act once the possession of the land has been taken and the land vests in the state from all the encumbrance. Para. The meaning of word vesting has been considered by this court time and again. In Fruit and Vegetable Merchants Union versus Delhi Improvement Trust, this court held that the meaning of the word vesting varies as per the context of the statute under which the property vests. So far as the vesting under section 16 and 17 of the Act is concerned, the court held as under para 353. In the cases contemplated by section 16 and 17 by the property acquired becomes the property of the government without any condition or limitations either as to the title or possession. The legislature has made it clear that the vesting of the property is not for any limited purpose or limited duration.